All right. What a way to dovetail between African History Month and Women's History Month with Shaka Khan. And that was a tribute concert for Whitney Houston. And that'll be a good way to start the show. Today, my returning guests here, Doctors Shannon Proctor and Dr. Vera Albrecht, who are both philosophy professors in the philosophy program of the Humanities Department, and both teach the philosophy of law course, and have been kind enough to be our regular guests as we play back the Supreme Court recordings of very famous landmark cases. Today, McRae versus Harris. If you're watching the show, you may have read the introduction, and so you know what's coming up. And maybe we should just go to the tape and our PowerPoint presentation, which my producer, Chris Pope, will be running for us. So without further ado, hold on. Let maybe just give an opportunity to the doctors to say hello. Do you want to say hello, Dr. Proctor, Dr. Albrecht?
Hello. Thanks for bringing us back, Hugo.
You got it.
Yeah, thanks for being back here. And that's actually a very interesting series. And I'm sure we will be back.
Okay. So yeah, we're just a quick synopsis. We're going to be dealing with whether Medicaid can be used to pay for abortion cases. And just to say again, you're watching LaGuardia Web Radio, WLGR, and I'm your host, Hugo Fernandez, for What's Going On. So, Mr. Pope, can you take us to the tape?
Arguments on Abortion presents the case of Harris versus McRae. The edited arguments are narrated by Congresswoman Eleanor Holmes Norton, delegate from the District of Columbia.
The court will hear arguments first this morning in 1268, Harris against McRae.
It's Monday, April 21st, 1980. Chief Justice Warren Burger has called for argument on a case which has generated much attention and hope on both sides of the abortion debate. It concerns government-funded health services and whether such services should offer medically necessary abortions. The Medicaid program, established by Congress in 1965, is a co-payment system. The federal government offers financial assistance to states which reimburse certain costs to medical services for the poor. In the summer of 1976, immediately after a decision of the Supreme Court reaffirming Roe v. Wade, Representative Henry J. Hyde, an Illinois Republican, proposed an amendment banning all Medicaid funding of abortions, except when necessary to save the mother's life. Cora McRae, a Medicaid recipient, was in the first trimester of a pregnancy that she wished to terminate. In September, on the day the law took effect, she filed a suit in the federal court in New York City on behalf of all indigent pregnant women. McRae alleged that the Hyde Amendment violated her rights under several provisions of the Constitution. She claimed that by refusing to fund medically necessary abortions while funding maternity care, the law discriminated against poor women and denied them their freedom of choice, as defined in Roe v. Wade. In January 1980, the federal judge agreed with her. The government appealed to the Supreme Court. Federal officials were encouraged by recent decisions of the court in favor of a restricted application of Roe v. Wade. In a 1977 case, Mayer v. Roe, the court ruled that neither the states nor the federal government have to pay for non-therapeutic or elective abortions for indigent women, even if they concurrently subsidize maternity and childbirth costs. Solicitor General Wade McRae will defend the Hyde Amendment for the federal government. Chief Justice Burger welcomes him.
Mr. Solicitor General, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court, At the outset, it might be helpful to state what this appeal concerns and what it does not concern. We regard the issues as two. First, whether the Hyde Amendment violates the equal protection component of the Due Process Clause by authorizing federal funds for medically necessary services generally and for abortions only when the life of the mother would be endangered if the fetus were carried to term, but not for other medically necessary abortions. And second, whether by restricting the availability of federal funds for medically necessary abortions, the Hyde Amendment deprives pregnant women of the liberty protected by the Due Process Clause of the Fifth Amendment or the religious freedom protected by the Free Exercise Clause of the First Amendment.
When asked to decide whether a law violates a fundamental right guaranteed by the Constitution, the court applies a restrictive standard, also called the strict scrutiny test. McRae argued that the court must apply a much less demanding standard to laws regulating access to abortion. His argument relied heavily on Mayer v. Roe, which declared that a woman's freedom of choice did not carry with it a constitutional entitlement to the financial resources necessary for the exercise of that right.
Our argument is essentially as follows. We contend that the Hyde Amendment is rationally related to the legitimate governmental interest in preserving potential human life and encouraging childbirth. We submit that the first approach is to determine the proper test to apply. We suggest that in Maher, this court made it clear that the proper test was the rational relationship test. In that case, which of course involved non-therapeutic or elective abortions, the court held that it was sufficient if the Congress had a legitimate objective and if the measure was rationally related to it. And in that case, it found that its interest in preserving potential human life and encouraging childbirth was an appropriate relationship, a rational relationship, and it upheld the challenge under the 14th Amendment.
One of the justices frowned at that statement. He pressed McRae to elaborate on the rational relationship test.
Would you make the same rational basis argument if the Hyde Amendment did not contain the exception for endangering the life of the mother? If it was her death rather than mere adverse impact on her health that was involved?
I think I would. I think I would say that you would make the rational relation, you'd still apply the same formula because you're talking about bestowing a benefit here. It doesn't prevent this woman from obtaining an abortion. It just denies her federal funding for that purpose. And
for purposes of analysis, at least, that some women will be denied abortions if they don't receive federal funding. I thought that was the thrust of the district court finding.
Oh, I think we have to. I don't think there's any question about that.
And then we therefore must also assume that some of those women will suffer serious medical harm.
We must assume that, and I think that's a judgment that the Congress must make. The Congress in the first instance did not have to appropriate money to reimburse any medical services whatsoever. And just because Roe said that the state could not punish a person under its criminal law for obtaining an abortion in the first trimester and its other refinements, that still did not obligate the court or the state or the federal government to reimburse her for the services. And we think that this is the kind of discretion that's vested in the Congress to decide what to do. And this, when we're speaking about a unique phenomenon, this is the only, or a pregnant woman is the only person seeking reimbursement for medical services in a situation where a potential human life is involved. And it is unique. And we say that the Congress has the right to make that determination.
But it must have a reason, I take it.
It must have a reason. And we think
but if it has a reason, any rational basis, that ends the role of the court.
I think if the court finds that, well, let's say it's a legitimate reason.
Regardless of what the interests on the other side are, under the rational relationship test, I take it you argue that there's no balancing involved at all. It's just if there's a rational basis, that's the end of it.
That's the approach in Maher, and that's the way we read Maher.
McRae shifted to the First Amendment challenge to the law.
Addressing the other grounds for the district court's opinion, the district court seems to say that since some women, as a matter of their religious convictions or conscience, would seek an abortion, that to refuse funding for that would somehow deny their First Amendment right to freedom of religion and free exercise of religion. We have a great deal of difficulty with that because it would seem that the free exercise clause prevents interference with it, but doesn't obligate the state to finance it. And we suggest in our brief that a person has no right to expect the state to furnish him with religious objects, for example, a Bible or any religious artifacts to enable him freely to exercise his religion. But this seems to be the thrust of that aspect of the opinion, and we think that this is a sufficient answer to that.
Justice William Rehnquist was not so quick to dismiss the issue.
Do you think the court would have ruled the same way had the government simply placed a very high tariff on Manischewitz wine, which is certainly part of a ritual of the at least Orthodox and perhaps conservative Jewry?
I want to make certain I understand the question. You're saying that if the government had placed an excessive tax on it, whether this would violate the...
So as to substantially raise the price in the guise of protecting, and perhaps in the legitimate guise of protecting the local manufacturers of Manischewitz wine.
Oh, no, I think it would not be at all if the government had a sectarian purpose for doing that.
Well, the question was, did you think the court would rule the same way? And the only possible answer is you don't know.
Of course. And I appreciate the court's suggestion of that.
Justice Rehnquist persisted, but Justice Thurgood Marshall's patience was exhausted.
So do you think the logic of the court's ruling on the free exercise clause would have led it to the same result in that hypothetical?
Well, not quite, because...
Mr. Gentleman, why don't you recognize the difference between drinking wine and having a baby?
I think that's a profound utterance with which I will concur immediately.
Justice Lewis Powell, who wrote the majority opinion in Mayer, posed a final question.
Would you summarize how the government describes the state interests that it relies on in supporting the Hyde Amendment?
Yes, if the court please, the state interest is the interest in preserving potential human life. This is the only procedure that would affect potential human life. And we suggest that this alone is a sufficient reason. Now, there are other reasons that we touch on in our brief. We suggest the Congress might have a sufficient reason in being reluctant to appropriate funds for procedures that some persons, large numbers of persons, find morally repugnant. But we don't rest solely on that. We think that either or both is a sufficient statement of a legitimate government interest.
Solicitor General McRae thanks the court and yields the podium to Rhonda Copeland. She waits for Chief Justice Burger's invitation to start her argument.
Ms. Copeland.
Mr. Chief Justice, and may it please the court.
An attorney for the Center for Constitutional Rights, Rhonda Copeland speaks for Cora McRae and other poor women. With passionate words, she urges the justices to seize this opportunity to reaffirm a woman's fundamental right to choose whether to have a child.
This case is one of simple principle. and singular magnitude. It involves the survival and the health of potentially millions of poor women in this country. And it involves the reaffirmation of the simple rule of law of the written Constitution that this court recognized in Roe v. Wade. It is very basic that, as the Solicitor General says, this case arises in the context of a Medicaid program designed to provide a broad range of medically necessary and essential services to poor people throughout the country. And it is very significant, as the Solicitor General agrees, that it is comprehensive and that but for the Hyde Amendments, it would cover abortion as a mandatory medically necessary service. Thus, the Hyde Amendments single out one medically necessary service. They preclude the exercise of sound medical judgment about the health of the pregnant woman, or indeed even of the fetal life. They prefer fetal life at the expense of maternal health and even maternal life. The district court found the Hyde Amendments repugnant to the entire scheme of the Medicaid statute. They are also repugnant to the most minimal safeguards of the Constitution.
Copeland agreed with Solicitor General McRae that the crucial question in this case was the standard of review adopted by the court. But she disputed his claim that a rational relationship test was appropriate. Her argument troubled Justice Rehnquist.
And the constitutional question that is presented to this court, and the one we will discuss today, is simply whether under the minimal standard of rationality in the equal protection component of the Fifth Amendment, the Congress can single out that one service.
But then you must be arguing not that it doesn't serve a legitimate or rational state interest, because presumably virtually any act of Congress will do that if applied, if rational scrutiny is applied. You have to say that one purpose of Congress conflicts with another, which is almost incomprehensible to me.
No, Mr. Justice Rehnquist, our argument is that in the context of this scheme, and also, and more importantly, in the context of equal protection, the preference for fetal life at the expense of maternal health and maternal life is irrational. And therefore, that preference cannot be drawn by the Congress.
Well, when you say the word irrational, I take it you mean literally that those who voted to adopt the Hyde Amendment belong in the loony bin.
No, Your Honor, I wouldn't say that at all.
Well, that's, to me, what the word irrational means, that they just went off the wall.
No, as a legal matter, I would not make that contention, Mr. Justice Rehnquist, but the point here is not how one characterizes that, but rather whether in the scheme of our Constitution it is rational to make that preference. And I would like to go back to the third trimester in Roe v. Wade, if I may. That is the point where there was no privacy interest of the woman.
Copeland told the justices that the protection afforded women under the Constitution and the decisions of the court were paramount to the state's interest in potential life.
And we say that in the context of the Constitution, which is written for the people, and as Roe v. Wade said, which protects born people, one cannot make that trade-off between people who exist and the potentiality of future life. It is the Constitution upon which we rely that says that this is a fundamentally irrational trade-off.
It's an argument that the fetus is not a person for purposes of the Constitution.
Your Honor, it isn't, that has been decided. It is not a person for the purposes of the Constitution, and I dare say that in our healthcare system, even if some whole person's life is at stake, we don't ask another person to involuntarily sacrifice their health or their life for their well-being.
In effect, Copeland said, the law prefers potential life to maternal life. She also pointed out that many poor women are also minority women with higher mortality rates.
The point, Your Honor, is that the life-endangering standard of the Hyde Amendment is supposed to protect women against life-endangering risks. The measure of those who ultimately die is not the measure of life-endangering risk. And once a woman, as the testimony showed and the district court found, is in a life-threatening situation, there is no guarantee for her survival.
Copeland moved on to the First and Fifth Amendment challenges to the law.
I would like to turn now, with the minutes remaining to me, to the First Amendment arguments and the First Amendment claims that were treated by the district court. The fact, I think, going back to this trade-off between maternal life and health and fetal life brings into full picture in this court the nature of the underlying interest. And that is that Congress wanted to, and the proponents of the Hyde Amendment sought, to take a position, and they did take a position, on the question of when human life begins. That question this court held in Roe v. Wade is impermissible, and I submit that it's impermissible under the Fifth Amendment. It is in addition, as the record below extensively documents, impermissible under the First Amendment. And both the First Amendment Establishment Clause and Free Exercise Clause.
Chief Justice Burger disputed her interpretation of the First Amendment. Copeland stood by her argument.
If your argument is correct, that would be, what you say, would invalidate almost every criminal law we have, because most of them coincide with, at least if they don't stem from religious tenets, the laws against murder and theft and...
Your Honor, we're not talking about a law...
The Ten Commandments.
We're not talking about a law which merely coincides with religious beliefs, and we're not talking about a law which, like the constraint on murder, is something which is part of the secular fabric of the society and accepted by everyone.
So, but its origins were religious.
That's right, Your Honor, but today is the point at which one has to examine what the purpose and what the character is of the belief that human life, full actual human life, begins at conception.
The result would be that religiously motivated people wouldn't be free, effectively, to lobby Congress to enact legislation.
No, Your Honor, it is not a matter of their freedom to enact legislation. They have an equal right to try. It is the question
of... If they succeed, then the legislation is enacted violates the Establishment
Clause. Because, as this Court has said many times, the Establishment Clause places a limit on the political entanglement of religion.
Copeland concluded,
the problem here is that not only is the anti-abortion movement essentially religious, but it's taking a position on a religious question. And therefore it is religiously biased legislation which impacts particularly on poor women in a Medicaid program which has as a principle to accommodate religion.
On June 30th, 1980, a slim majority of the justices, 5-4, voted to uphold the Hyde Amendment. Justice Potter Stewart wrote the opinion in Harris v. McRae for the majority of the moderate to conservative justices. He agreed with Solicitor General McRae that Mayer v. Roe was a sound and appropriate precedent for upholding the Hyde Amendment. He endorsed the rational basis test promoted by McRae and found the Hyde Amendment to be rationally related to the legitimate governmental objective of protecting potential life. Stewart denied that the law violated the due process and equal protection clauses of the Fifth Amendment. Although government may not place obstacles in the path of a woman's exercise of her freedom of choice, he wrote, it need not remove those not of its own creation. Indigency falls in the latter category. Stewart noted that although Congress has opted to subsidize medically necessary services except abortions, the Hyde Amendment leaves an indigent woman with at least the same range of choice in deciding whether to obtain a medically necessary abortion as she would have if Congress had chosen to subsidize no health care costs at all. Finally, Stewart denied that the Hyde Amendment violated the religion clauses of the First Amendment. The fact that the restrictions might coincide with the tenets of the Roman Catholic Church, he wrote, does not by itself violate the Establishment Clause. All 4 dissenting justices filed separate opinions. Justice William Brennan denounced the Hyde Amendment as a blatant attempt to coerce indigent women to bear children that they would otherwise elect not to have, and to achieve indirectly what Roe v. Wade said it could not do directly. Justice Thurgood Marshall had strong words for the majority, which he said made a mockery of the equal protection clauses of the Constitution. By imposing a crushing burden on poor women seeking an abortion, Marshall continued, the court's decision represents a cruel blow to the most powerless members of our society. The fracture of the court on the issue of public funding of abortions reflects that of society. A clear majority of people support a woman's right to choose. Many less approve of publicly funded abortion services. Every fall, when Congress reconsiders the Hyde Amendment, the issue is intensely debated. In September 1993, Congress voted to ease the Hyde Amendment, allowing public funding for abortions required by the victims of rape or incest. President Clinton later signed a federal order requiring the states to comply with Congress's mandate. A few defiant states refused to obey. Challenges to this defiance have not yet reached the Supreme Court.
Arguments on Abortion is a production of the Earl Warren Bill of Rights Project of the University of California, San Diego.
Okay, and we are at the half-hour mark, so I'm just going to do a quick station ID. You're watching the show is What's Going On. I'm your host, Hugo Fernandez, and you're on LaGuardia Web Radio, WLGR. And my guests today are Dr. Shannon Proctor and Dr. Vera Albrecht of the philosophy program of the Humanities Department, who both teach the philosophy of law. And we've just heard recordings of the oral arguments of Harris versus McRae, which dealt with the issue of are we obliged through Medicaid to support, pay for abortion, and how that involves the Hyde Amendment. So I'll take it away, doctors.
I think one of the things I wanted to start out with, because there's this distinction that's going on in the case that I know if I were teaching this, I'd really want to tease out that they don't explicitly pull out in what we heard, which is the difference between what we would call positive and negative freedoms. So this difference, like a positive freedom being something like the government in some regard has to not just prevent any kind of intrusion into your life or interference into your life, but actually has to provide you the means of which to achieve a certain right. So you might say that Medicaid is providing the necessary means for people to achieve a certain degree of healthcare as a right. However, if they're putting this limitation on, the court seems to think that's not an undue burden. So the court's sort of saying, we're not interfering with the woman's right to decide to have an abortion. We're simply not giving the funds in order for her to achieve that. So they're saying we don't have the obligation to provide the positive freedom here, or the positive right to get this. Does that make sense, the way I'm sort of trying to frame that out?
Yeah, and I'm as I listen to it, I'm trying to think of other, like, for example, what is it? The Second Amendment, you have the right to bear arms, but the government does not have to provide you with a gun.
Thankfully.
But
yeah.
I think that's one of the most crucial issues here. This between, rights, or if you wish, you can also frame it in terms of the difference between rights and privileges. Something's a right, the government has to protect this right, and that's what the Constitution is all about. At the same time, if something's a privilege, it's, well, you can do it, but you don't have to, and the government doesn't have to support this or even protect this. And I think that's I think one of the most fundamental issues here.
Yeah.
So what are you in just listening to you talk about this, are you saying that you agree with the majority opinion?
No.
Oh, no.
In this case, to be more complicated philosophically than the other cases we've talked about in this series so far.
Mm-hmm.
if I were the lawyer, I would have really pushed on the potential for human life aspect that the government was relying upon. I think that's, if we don't know where life begins scientifically, then it's not clear to me that we know where potential life begins either. And everyone in that case was treating this like a clear, understood concept that, when we're talking about a fetus, that's where the potential for life begins. And they kept saying there's no other healthcare emergency, let's say, that ever involves the potential for human life. And that, to me, off the top of my head, just seemed patently false. I mean, if you were talking about anything having to do with the reproductive system whatsoever, it seems like there's a case to be made that there's a potential human life that is being affected. So that, to me, is a more promising. I didn't find the First Amendment approach promising at all. Neither did the justices.
However, I would say what I found interesting was that Kaplan came across to say, well, look, it's this
by the way, I should mention, I misspelled her name in the PowerPoint. It's actually Coppolan.
Coppolan, okay.
C-O-P. You're pronouncing it correctly. I misspelled it, along with Rehnquist's name and Shaka Khan's name earlier today when I sent an email. So that was 3 misspellings today for me.
Okay, get like 2 points off for it. Anyway, just kidding. So Copeland made a point that even a person born, and here she kind of hints at that the distinction isn't really that relevant. She says even a person who is born already cannot be asked to sacrifice her life for the sake and well-being of another person. This is some of you, and of course Shannon knows this, but maybe some of the listeners know Thompson's argument in favor of abortion, where she makes the point that the core question is not one of personhood, but rather if one were asked, and she has a scenario, if you were hooked up to a famous violinist and to, make that other person survive, you would have to be disconnected, but then the other person would die. Would you have the right to do that? And here it ignores this whole distinction between, being a person or not person. And I think Copeland here hints at it, and I think she could have kind of maybe pounded on it a little bit stronger, because her point was that the law actually prefers potential life over maternal life.
And if you read the dissents, you'll see that oftentimes in cases that they're talking about, it's arguable how much there is a potential for life in the cases they're talking about. So it might not have been, the abortion might not have been clearly necessary to preserve the life of the mother, but in many cases you're talking about where there will be significant harm to the mother's health, or where there is little chance of viability for the fetus upon birth, right? So it's not even clear how much the potential for life is even the focus here. Mm-hmm. And one other thing I'd want to point out that didn't come up much, I mean, they're obviously talking about how this affects poor women and women of color, but there's a way to connect this to some of the history of forced sterilization, I thought, in this country. And this seems like the completely opposite motivation that the government had. On one hand, saying that like these potential lives must be preserved. And then in other instances, they're going about making it so that poor, indigent, and women of color could not become pregnant in the first place, which just,
it's interesting because this attorney, Rhonda Copeland, actually was one of the founding members of the faculty of the CUNY School of Law, and she still, I believe, maybe is involved with the School of Law. And I thought it might be interesting to bring her back in, offer her an opportunity to come on the show one time, and the both of you could tell her how.
Maybe let's not tell her what she is.
I wonder if she does that. She does do, like, if she second guesses her, and then, which is, I've certainly done. I remember when I did my mock trial in, I don't know what it was, 7th grade. And I was, how I, of course, I should have done it this way. people could have made the case. So it's literally the way the case is argued. I mean, for me, one of the things that's kind of interesting is that idea, the indigent, right? That that basically Stewart is saying that yes, we will allow you to do this, but we're not responsible for the fact that you are poor, so we don't have to actually support our ability to exercise this decision on whatever grounds it is. And so it gets interesting in these cases a lot of time. I mean, I remember back in the previous case that we were looking at, which I'd have to pull up here, I think it was a Griswold versus Connecticut. This idea that saying like this would be something that Congress would have to take care of. And again, this is one of these ideas of the fact that that we have a country where it is permissible to allow a large percentage of the population to be underfed, to not have housing, and to lack proper health care. And so anyhow, I mean, that's a little bit interesting to me.
Yeah, I mean, but that connected, I think, into maybe the reading about strict scrutiny, right? So is indigency, well, that's a hard word for me to say, is that a category that requires a higher level of legal scrutiny or judicial scrutiny? And I get where you're going with this, Hugo, which is that perhaps there's a lot more to unpack about who's responsible. We're talking about socioeconomic status, right? What are the cultural conditions such that people need to be on government health care, right? And I think today the argument that that everyone in this country should have access to free health care has a lot of support behind it too. So
in the best interest of
everyone,
of the country, whatever.
Right. And I mean, you might also think, I mean, if it's possible to provide healthcare, which is really a very basic kind of, support for society in general. If it's possible, I mean, if a poor country can't manage to provide healthcare for all its citizens, that's just a matter of that there's no possibility. But this is one of the richest countries in the world. So how can that be that other industrial countries can provide healthcare for all its citizens, and say just our neighbor Canada can, and we can't? And on that point also, I mean, certainly they treat this as if poverty was a choice of people. So this is, you may argue, maybe it's their own doing or lack of doing that they're poor, but certainly it's not something people consciously choose to be poor. And a little bit it seems on this, on the opinion that agrees with the Hyde Amendment, that this sounds like, well, you know what, that's your own problem if you're poor.
And what's interesting, again, this idea of that the government is invested in saving life. But, what I keep finding in all of these, the cases we've been looking at, which are focused on reproductive rights, right, arguments on abortion, is that they're not interested in life. They're interested in birth. And that, because once the child is born and is indigent, chances are, that the chances are higher that the child of a mother who would need an abortion is probably indigent. The government does almost nothing to step in and to make that life worth living, in the sense, again, with what I've been talking about, which is, shelter, food, and healthcare. So I think it seems like this kind of peculiar circle or triangle or something that's going on with the arguments here.
But I guess, I feel like this is something I might have brought up when we were talking about Roe v. Wade, which is that if you get historically where politically the issue of abortion really came in, it's quite debatable whether there is even a tremendous interest in saving children, right, in birth, or to what degree there is a political maneuver in which to get certain groups of people from like Southern Democrats to switch over to Republicans and to use this as, I guess you'd call it, a wedge issue. So if I think bringing some of that historical analysis in maybe makes it so it's not so hard to understand what looks like a glaring contradiction of we want to preserve life until we actually have the means to preserve life through the kind of programs you're talking about. It's a cynical interpretation, but
it's very cynical. Because you might just argue that the government protects life only until it's born, and after that, okay, you're on your own.
I would think that, and by the way, we're coming to the last quarter hour of the show, and we have a lot of guests, and so I will invite them if they'd like to send us some questions through the chat function in Twitch. I don't know. I think I lost my point when I was trying to make that, but just something that you were touching on there, but it'll come back to me.
Hugo, I just would like to just touch quickly on it because, I mean, Shannon correctly said, well, that whole First Amendment argument is really a little fuzzy. I mean, how is that related to religion? But I just want to add one thing that, the court here said or asked. I mean, that religion doesn't, or there isn't really this relationship that the government supports religious items, such as you can't ask the government to buy your Bible. Of course not. But it would be very different if the government would, provide you with a Bible, if it's a Bible, but if you ask for getting money for Quran, it would deny you. So that would really be the question, because what Copeland pointed out at the beginning, that while maternity and birth is covered by Medicaid, abortion is not. So there's a discrepancy here, which goes really in favor of one side. And
I think the other side, see, that's where I totally get that interpretation. What's so confusing to me, and maybe if we'd read more of her argument, right, it would be clearer, obviously. Mm-hmm. She's saying that there's a religious foundation to the Hyde Amendment, but it's hard to argue that there's this other side. So the analogy of the Bible and the Quran isn't going to quite map on, because it's not as if there's a religious group, although maybe this is something I just don't historically know enough about or have enough religious knowledge about. I don't think there's a religious group that's requiring women to terminate pregnancies under particular conditions. Does anyone know am I mistaken on that fact?
You know what? I think it's a position that she kind of, it's not really pointed out, or maybe we're missing it here, that it's the religious freedom not to be religious, right? I mean, if you were a Catholic or if you were religious, you are against abortion, but you have the freedom not to be religious. That's how I read the argument.
Yeah, it's funny because your good studies, Shannon read the dissenting and all the opinions, and I guess we could get a hold of the brief that she submitted, and there are obviously, we only listened about a half hour of the arguments. Right. A lot of times they're longer and they've been edited down. But a few points I just wanted to touch on is the fact that the government doesn't buy Bibles, but the government does allow the churches to not pay taxes on what they bring in. So someone could look at that and say, well, in a sense, we are subsidizing religion. And, one of the reasons that we can't afford to pay healthcare in this country is because 50% of our GNP goes to the military. That half of every tax dollar is going to supporting that. But the one thing that I was thinking about, and probably the idea behind the Hyde Amendment when it first came out, is this notion that if the government paid for abortion, what stops a person from utilizing that as their method of birth control, and basically when they get pregnant, having an abortion? Now, probably anybody who's had an abortion would tell you that's not what you'd want to do, but this is the argument that people would make, is that people would just take advantage of that and have one after another, right?
I mean, it does seem like a bit of a red herring, but I guess I'm also willing to bite the bullet on this one and say,
maybe they said that at the time.
Oh no, I understand people have made that argument against abortion. I'm saying
Right.
I'm willing to bite the bullet and say, well, if you have the right to have one, I'm not sure what then the argument becomes that if you were in need of a second or third or fourth, you could not. Right. You sort of have to buy into the initial argument against abortion to then easily make the case that having a subsequent one would be morally or ethically wrong. Which I don't buy into those arguments. Does that make sense? I had to stop saying, does that make sense? But yeah.
No, that's good.
But that's a different question, because you're right. If you say, if you have the right to do this, if you have, say, the right
subsidy.
to the subsidy, if you can have it more than once. But I just want to correct you on one thing, Hugo, if I may. What you said earlier, of course, a great amount of our resources go to the military, but at the same time, the United States spends more tax money per head on healthcare issues than any other country in the world. Yet most people do not have health, or a large number of people are not covered by
through the private. You're including dollars from the private sector.
No,
right?
I'm talking tax dollars that are spent for healthcare
per capita.
Per capita, yes.
Oh, I never knew that.
Yeah, it's not that we don't have the money. It's just that the money is just distributed differently, and that healthcare money is spent not on people getting healthcare, but otherwise.
Okay.
So,
and to go back to this First Amendment, when I was listening to the religious question against the First Amendment, and by the way, what I love about this show is that I have to go look up all the amendments to make sure I know which one they're talking about. And obviously the freedom of religion, but it goes back to this issue that taxpayers subsidizing something which they believe against religiously. Is that that's...
I think what they were saying is that at least what she was trying to argue is that the government can't create a law that is originally and significantly religious in nature. It's not that religious input from people who hold strong religious views can't become a part of the creation of a law, but that law ultimately needs to be quite separable from the religious dimension of it. So it's not that it can't have origins in religious ideology. It's that that can't be the sole or even main foundation of the law. And she's trying to say this law, this Hyde Amendment, there's no other way to interpret it than as a religious law, as the imposition of a religious approach, which is then going to violate the Establishment Clause.
And also, importantly, she really points out that this is the only exception. So it's really broadly covers all sorts of procedures, but that's the only exception. And she points out that the anti-abortion movement is religiously biased. So it's that it has its origin there, as you said, and it does not just by chance concur with it as some other rules, as she was pressed on when then we came to even laws against murder, which was a little bit also facetious kind of, but it's that the laws against murder, for instance, although they concur with religious sentiment, are not motivated by it.
We're coming close to the end of the show, so I would like to give you both an opportunity to just have your weigh in. It's interesting that they talked about the Hyde Amendment is something that keeps finding its way to Congress. It's that Clinton had added some freedom to it. Obviously, these states have responded by not going along with the federal policy, and it's working. They're still working their way to the Supreme Court. Any thoughts about where this is going to head maybe in the next 10, 20 years?
Let me just say, if you had asked this question 5 years ago, my answer would be very different, because the Supreme Court went a different direction now with the latest nominees. So I don't think this will go anywhere within the near future. Personally, I'm pretty amazed it doesn't, because as much as you may say women have the freedom to choose an abortion, if they don't have the resources, they effectively do not have that choice.
And I would just add it seems again to bring up the degree to which we want to rely upon the Supreme Court to be making these decisions, and that there are not non-legal, but ways outside of the legal system in order, like there are ways in which you could do activism around these issues, raising money, making sure that there's access in ways that don't rely upon the Supreme Court, because it doesn't seem going forward that the Supreme Court is likely in the next 5 years to make decisions that are sort of more providing more freedom in terms of pregnancy and abortion. It seems like it's likely to go the opposite way.
Yeah, and in fact, I think what we're looking at, or what I guess everybody is waiting for, is the case that will challenge Roe v. Wade. And I don't know on what grounds, but if it finds itself in front of the present Supreme Court, I don't like our chances.
No, not at all.
Not at all. It's much more likely to be restricted or further restricted.
Right.
All right. I wish we had some good news on today's show. But I wanted to just talk about, going forward. We haven't got a date yet, but our next case, which I believe I was looking up, is Bowen versus Kendrick, which will be dealing with sexual education in the public schools and whether you can fund programming which offers abortion as one of those options. So I just want to thank the two of you for coming on again, dealing with all these messy questions. There's nothing clean about these cases, and not to mention the fact that just because let's say a particular idea wins at one point, that down the road the argument can't be made in the other direction. But you've been watching what's going on here on LaGuardia Web Radio WLGR. Your host Hugo Fernandez. These episodes are May It Please the Court, and my guests have been Dr. Shannon Proctor and Dr. Vera Albrecht of the Humanities Philosophy program and the Philosophy of Law class. I mean, those of you who may be jockeying for classes, this is give you a taste of what if you signed up for this class. You might experience, and we've been dealing with the case of Harris versus McRae and whether Medicaid should fund abortion, particularly in the lives of women who can't afford it to do it on their own. So I just want to thank everybody for listening. I want to thank Mr. Pope. Except for my misspellings, I think we're getting better with our PowerPoint audio accompaniment, and Dr. Riccio, who's manning the Twitch stream. And we're going to take out the show in somewhat the way we went, a little something I found since it is Women's History Month in honor of the late Tammy Tyrell, who was Marvin Gaye's one of his great duet partner in the 60s. So thanks for listening, and see you next time.
Bye.
Thanks. Bye-bye. Thank you.